A number of elements are required to create a formal will. However, if someone without legal guidance is trying their best to make a will, but they don't meet the formal requirements, the legislation can sometimes save the will. The Succession Act in Queensland says, in relation to a document or a part of a document that purports to state the testamentary intentions of a deceased person, the document forms a will of the deceased person if the court is satisfied that the person intended the document to form the person's will. In this case, Gail Marshall, 3 years before she died, wrote a document which said, slightly edited, "I, Gail Marshall, being of sound mind, hereby give my son Brendan Stewart to take care of all my affairs if I cannot do this myself. I give him not only next of kin, but to be my power of attorney, to distribute my worldly possessions or take care of my affairs if needed. He is aware of my wishes, and I trust him to take care of anything I can't. These are my wishes, and this my last will and testament." The will was signed by Ms. Marshall and dated, but was not witnessed. After Ms. Marshall died, her son Brendan sought an order allowing him to administer the will. Justice Henry was required to consider whether this will could be saved as an informal will. He noted that there was a threshold requirement for a document to be considered a will. It had to express testamentary intentions. He said, "In order to purport to state testamentary intention, the document must, in what it states, purport to indicate what should be done with the deceased property upon death. Breaking that requirement into its two aspects to aid analysis, it must purport to indicate that it is to take effect upon death and purport to indicate what should be done with the deceased's property." This document did neither of those things. It gave Brendan power of attorney, which is a power that operates during the life of a person. So the document did not rely on her death to become effective. And then, while the document said that Brendan should distribute her worldly possessions, it gave no instruction on how. As a result, there was no will, and Ms. Marshall's estate was distributed according to the rules of intestacy.